Thank you.
Counsel for the appellate, please.
May it please the court, I'd like to ask for 1 or 2 minutes of rebuttal time in response to my opponent's oral argument, if it may please the court.
Granted.
Okay.
Madam Clerk, keep track of that at the 2 minutes.
Before you start, since
What time
Tom
stop?
explained the logistics, you actually go to the podium here.
Okay.
I beg your pardon, I should have.
When is my time starting then?
It'll, I'll come back.
Gotta look to her for that.
Try to do something.
Okay. This
Counselor,
case is,
you may proceed.
Thank you. This case is about plaintiffs, the McGonigals, against defendant Southwest Living Incorporated, Florida Corporation. This case surrounds the events of summer 2010, in which the plaintiffs, the McGonigals, enrolled their twin sons, Robert and Richard, in the University of Southwest Florida in Fort Myers, Florida, and due to overcrowding of on-campus dorm facilities, sought off-campus housing and arrived at enlisting their sons in Southwest Living's dorms off-campus. The McGonigals were taken on a tour of the facility and shown a double unit in which their twins would have adequate space and a study environment which would be feasible and comparable. And it was also represented to the McGonigals and the twins that they would have laundry facilities that would work on a perpetual basis, and that they would have a smooth process by which they'd be able to qualify for Florida residency for in-state tuition purposes. However, none of these promises came to fruition. Today, I'm going to argue that the McGonigals, even as non-consumers in the transaction concerning their twin sons, can bring claim under the Florida Deceptive and Unfair Trade Practices Act, and that Southwest Living's conduct amounts to deception under FDUPA. With regards to the first claim, the Florida legislature amended the relevant statute in 2001, replacing the word consumer with the word person as to who could bring claim under FDUPA, according to Kelly v. Palmer. However, Cortez v. Net Transactions contends that this was only meant to extend legal personality to business entities and not non-consumers. However, the legislature realized that many businesses consider themselves immune to suit and want businesses to become more receptive to their customers' need and feel a necessary sense of vulnerability. So therefore, anyone who not only suffered a loss under FDUPA, but anyone who was negatively affected by a fraudulent or deceptive act would be able to bring claim under FDUPA. Hence, the first claim should be fulfilled.
Counselor, with regards to what someone would need to show under FDUPA to have standing, would you need to show monetary harm, or is it just any aggrieved person under the Act if we adopt what you are arguing and what was found in Kelly?
No, it would be anyone who was aggrieved under FDUPA, or anyone, the Florida legislature intended for anyone who was negatively affected by a deceptive act, not necessarily financial harm, but anyone who could claim for monetary damages or punitive damages, basically anyone who negatively was impacted as a result of a deceptive act. And that would extend to the non-consumer or the McGonigals in this case. With regards to the second claim, deception is properly alleged under FDUPA if there is a representation, omission, or practice that is likely to mislead the consumer acting reasonably in the circumstances to the consumer's detriment. With regards to the first element of a misrepresentation that misled the McGonigals, Southwest Living showed, represented to the McGonigals, that their twins would be receiving a double unit or something of comparable quality. Admittedly, the language in the housing contract implied that the twins would not be guaranteed any particular unit. This did not imply that they should have received something of considerably lesser quality or lower quality.
Counselor, everyone here at some point has been a consumer, and I'm pretty sure in some way, shape, or form, everyone knows to be a little bit guarded when they're paying attention to the representations of a salesperson. Is it really reasonable for a consumer to rely on what the realty company said in this case with regard to subjective assertions of how nice the apartments would be?
But yes, because in this case, the McGonigals invested over $30,000 in their twins' resident facilities off campus, that any reasonable person would have assumed that when they're being shown a double unit, that something of similar or comparable quality is going to be available when they actually move in. The unit that they actually received when they moved in was of considerably lesser quality, which the twins had to share a single room, and they didn't have as many amenities as they would have had, and it basically compromised the value of what the McGonigals paid for. Hence,
Counselor, does the Act, excuse me for interrupting, but I'll do this. Does the Act embrace assumptions by consumers, or does it not, in fact, it embrace actions by the alleged deceptive and unfair person?
I'm sorry, can you rephrase the question?
Does the Act embrace assumptions by a protected person? You stated any reasonable person would assume that. we're more concerned here as a court with what was said, what was done that's unfair or deceptive.
Well, as the statute would state, as a reasonable consumer would act under the circumstances, or as a reasonable person would act under the circumstances. So therefore, the first element of deception should be fulfilled. With regards to the McGonigal's acting reasonably, they made sure everything in the housing contract was cogent and concise and proceeded as the reasonable person would have, and they had no reason to suspect that deception was taking place or about to take place.
Counselor, I have the contract here, and it is very clear that you're not guaranteed any specific room, you're not guaranteed any specific furnishings, and that the representations made by the realtor in this case were just that, representations that aren't in fact guaranteed. Why is it reasonable to rely on what I think Ms. Sprite said if the contract said otherwise?
Because the McGonigals had invested a considerable amount of money in the housing contract and had paid over $30,000 for their son's dormitories, and the contractual language is going to, I'm going to argue, it's going to imply that they're going to receive similar amenities. It doesn't mean that they're going to receive the identical amenities, but something similar, not something drastically reduced in quality, which is what the McGonigals were getting. So, with regards to the third claim, that the McGonigals acted to their detriment, it can be said that this is fulfilled because the McGonigals invested so much money in their twins' housing enterprise off campus, and by the time the middle of the semester had come around, this money was non-refundable, and McGonigals could not recover at this point.
Counselor, I know there's a lot of money at stake here, but at the end of the day, these seem like pretty small issues. We're talking about a washing machine not working all the time. We're talking about noise in a college dormitory. Looking at any one of these things, it really doesn't seem like that big of a deal. Should we look at each act uniquely, or should we?
It's a holistic assessment, because everything put together amounted to deception. Because Southwest Living, and this will extend to the fourth element of probable not possible deception, Southwest Living should have been substantially certain that these problems had arisen before, and a reasonable consumer would have relied upon the fact that they would have received a double unit or something of similar quality, and Southwest Living still represented to the McGonigals that there was absolutely nothing awry about what they were receiving at all. So for the foregoing reasons, I'm going to argue that the district court's granting of summary judgment should be reversed. Thank you.
Councilman, sorry to be a bother, but before we wrap up, what's your name?
Gregory Briskin.